All right, well, good afternoon, everybody, and welcome to the third and final instalment of Clifford Gouldson Lawyers COVID-19 and Your Business, Where Are We Now webinar program. Thank you to those who have joined us for the first two webinars. The first one was presented by Danny Clifford on workplace law or employment law, and the second one was a commercial and property COVID rent regulations topic presented by Amanda Tolson and Carly Braylick. So thanks to those who are multiple attendees, but a bigger thank you, of course, to those who are joining us for the first time to listen to me. Today, I'm going to be talking about a few different topics. So I have to move reasonably quickly because we've only got the half an hour. I'm going to do it in a slightly different order to the title, in the sense that I'm going to do credit management, director's duties, and then insolvency law reform. So hopefully we keep moving from topic to topic, and that'll maintain interest. Look, whenever I deliver seminars, I like them to be as interactive as possible. Now, I appreciate that that's a bit harder today because it's a webinar, not a seminar, but you do have the ability to ask questions in the chat. Carolyn of our office is standing by to put those questions forward to me so I can see them. So please submit them as we go, and I'll endeavour to answer each of them as I get to the end of each slide, or perhaps at the end of the seminar or the webinar. But again, please don't hesitate to ask. Get involved, because the more you are involved, the more you will learn. So just go on to the next slide, which is not all that exciting. It wouldn't be a lawyer's webinar without a disclaimer. So I'll just give you a moment to read that very important information. Okay, so let's get into the substantive part of today. First topic, credit management. Now, that can be both front end and back end. So if it's front end, then you're looking at things like procedures and processes and systems to limit or minimize debt in your business as much as possible. Or it can be back end where you've got a recalcitrant debtor who won't pay and you're pursuing recovery of the money owed to you. On the 24th of March this year, when COVID was in full swing, or just getting into its full swing, the federal government here in Australia passed the Coronavirus Economic Response Package Omnibus Act, amongst other things, to provide temporary relief for individuals at risk of bankruptcy and temporary relief for businesses at risk of insolvency. So that was the general sort of purpose of the legislation. That relief was originally slated to end on the 24th of September this year. It was only meant to last for 6 months, but on the 7th of September, it was extended, as it says there on the slide, to the end of the year. Now, whether it will be extended again remains to be seen. For example, until the end of March next year, like JobKeeper and JobSeeker. I don't think so, but I'm open to others' opinions on that. I'm going to run through this slide reasonably quickly because I've been through this material. There was a webinar that I delivered in April that covered this topic, and we've done a legal alert to our email list earlier in the year. But put simply, creditor statutory demands and bankruptcy notices. Creditor statutory are both credit management or debt recovery tools. Creditor statutory demands can only be issued to companies. Bankruptcy notices can only be issued to debtors, individual debtors. Originally, pre-24 March this year, the minimum debt before you could issue a creditor statutory demand was $2,000, and for bankruptcy notices, $5,000. Those thresholds were both increased to $20,000, and the time to pay or respond to a creditor statutory demand or a bankruptcy notice was increased from 21 days to 6 months. Now that has, in our experience, had a practical effect of meaning that nobody's using stat demands or bankruptcy notices as debt recovery tools. The advantage of them is that if they are not complied with within the time, usually 21 days, but now 6 months, the law deems that to be an act of insolvency. And that's relevant because you can't then move on to the next step in the debt recovery process if you are seeking to wind up or force a company to liquidation or force an individual into bankruptcy. You can't go on to the next stage of that process unless the company or the individual is insolvent. The failure to comply with a stat demand or a bankruptcy notice is deemed to be an act of insolvency, and that's why they are usually a powerful tool. But no one's using it at the moment because 6 months is far too long to wait to move on to the next stage of the insolvency process. That's what we've seen anyway, even where the debt is more than $20,000. Court or QCAT proceedings are seemingly more attractive or still a viable route because, again, as I said, the 6 months that debtors have to comply with stat demands or bankruptcy notices. So we're not seeing too much of a slowdown in, or we haven't seen too much of a slowdown in people suing debtors to recover money. Probably a little bit, but certainly no stat demands or bankruptcy notices. Now, this 3-month extension from the end of September towards the end of September to the end of this year will give debtors a further short period of respite. But really, in the scheme of things, 3 months is not that long, and creditors don't have to wait too much longer before they can more vigorously pursue recovery of their debts via other means than just the court or QCAT. And what we are seeing is that there's generally, as I said, there was generally no restriction on suing people in the courts or QCAT other than if you are a certain type of landlord and you're owed rent by a certain kind of tenant. You can't sue in those circumstances to recover the outstanding rent. And I understand Amanda and Carly spoke about that last week. But otherwise, we're still seeing people willing to pursue recovery of debts through the courts and QCAT. Because, you know, the first step in that procedure or process is once you file and serve your claim or application, depending on which jurisdiction you're in, the debtor only has 28 days to respond or defend. And if they don't, you can get default judgment, move on to enforcement of that judgment, which then you can wield some pretty serious, hefty sticks. So any questions come through there, Carolyn? Doesn't look like it. All right, well, we might, if not, we'll move on to the next slide. Now, director's duties, the one that I'm going to focus on today is personal liability for insolvent trading. One of the other measures of that act that has been extended to New Year's Eve was to give temporary relief to company directors from that personal liability. It's actually also relief from their personal duty to prevent their companies from trading whilst insolvent, or by not causing their companies to incur debts that would cause their company to become insolvent. Now, if you incur a debt or cause your company as a director to incur a debt that you cannot pay as and when that debt falls due, then arguably your company is insolvent. So that has given some freedom, I guess, to directors to keep trading where, you know, they might be running up a debt that they can't necessarily afford to pay within terms. Now, the company doesn't stop being liable for that, but the director has been since 24th of March and won't be liable personally for that until next year. So there's actually, not only can directors become personally liable for the debt in those circumstances, but they actually commit an offence of insolvent trading for if they cause their company to incur a debt that at a time either when their company is insolvent or causes their company to become insolvent. But yeah, no personal liability between 24 March and 31st December this year for directors. One small caveat on that is that the debt or debts must have been or be incurred in the ordinary course of business. So you can't just go out there and wildly spend, I suppose, is the object of the legislation. It just has to be, I would say, in the normal course of business, being the normal incurring of supplier debts. Good question that's just come through. After December, the directors then become liable retrospectively. I believe not is the answer for that. If you incurred a debt during the period 24 March to 31 December, then you can't be held personally liable for that debt as a company director. If you incur a debt that causes your company to become insolvent, or if your company is insolvent as at 1 January 2021, different story. That's when a director will become personally liable. Now, to obtain this protection, the company must be eligible in that. Sorry, I'm jumping to the next dot point here on the same slide. Before this act came in March, there was an existing protection from personal liability for insolvent trading for company directors. There's another way in which they could access that safe harbour, and that is to be eligible, their company must have satisfied the statutory prerequisites, those mainly being all of its employee and taxation requirements must be up to date, and its directors must develop one or more courses of action that are reasonably likely to lead to a better outcome for the company than the immediate appointment of an insolvency accountant, i.e. the involvement of a liquidator or an administrator. So it's a bit of a broad test, but I think what's insightful is that there's been very little, certainly last time I checked, there have been no cases to interpret what, for example, is a course of action that's reasonably likely to lead to a better outcome for the company than liquidation or administration. It seems to be a reasonably easy test to meet, particularly if you develop that course of action with the assistance of an appropriately qualified insolvency professional. In my view, that would make a court far more likely to find that the director or directors are immune from insolvent trading liability and have access to the safe harbour. It usually comes into place after a liquidator or administrator is appointed and is looking back at transactions and saying, hey, listen, that debt was incurred at a time when the company was insolvent, or that debt caused the company to become insolvent. Director, you're in the gun for that debt. But the director turns around then and says, well, no, I spoke with an insolvency accountant at the time, and we developed a plan that we thought at the time was going to lead to a better outcome than liquidation or administration where we are now. And I think as long as you do something and keep records of it and speak to the right people, you'll go a long way towards, as a director, protection from insolvent trading, personal liability. No questions, Carol, on the back of that one? Great. All right, we'll move on to the next one. Next slide. Now, this is where it's a bit more new and interesting for those who find this sort of stuff interesting. So on the 24th of September, which is the same day on which the credit management and directors' duties relief was extended, the government announced changes to Australia's insolvency framework by introducing this Corporations Amendment Corporate Insolvency Reforms Bill. People have described this proposed law as the most significant reforms to Australia's insolvency laws in 30 years. Now, it says there on the slide, this law is due to commence at the beginning of next year. And these reforms are designed to ensure that small businesses benefit from the new processes as those temporary relief that we have spoken about earlier today to protect financially distressed businesses expire at the end of the year. So the relief from, or the extensions to creditor statutory demands and bankruptcy notices and directors' personal liability for insolvent trading, they're all due to come to an end at the 31st of December. But these new reforms start on the 1 of January. So that's one main reason why I don't think that that relief will be extended beyond New Year's Eve. Now, the reforms focus on the restructure or liquidation of companies that have less than $1 million in liabilities. So it's not going to apply to the big end of town. I mean, a lot of large liquidations or administrations that I've seen, the debts owed by those companies far exceed $1 million. But so this is really designed to help small business, small and medium business perhaps, but certainly small business. And these changes include a new debt restructuring process that allows directors to remain in control of the business, arguably for longer than what they would have done before these laws come in. So one advantage to the company directors, is that whilst a debt restructuring plan is being created and then creditors are considering it, unsecured and some secured creditors are prohibited from taking legal action against the company, and personal guarantees can't be enforced against the directors. Now, high level speaking, businesses have 20 business days, or companies have 20 business days to create a debt restructuring plan, and submit that to their creditors, and 15 days for creditors to consider and vote on it. And the plan must be approved by 50% of creditors in value, not of number. Like the temporary relief between March and December this year, all employee entitlements must be paid in full before the restructure plan is voted on by creditors, and taxation reporting obligations must also be up to date before businesses can access these reforms. And if the debt restructuring plan is approved by 50% or more of creditors in value, then a registered liquidator is appointed to oversee the plan or its implementation. If the majority of creditors vote against the plan, then business owners can choose to enter into either a voluntary administration or undertake a new simplified liquidation process with a registered liquidator, or you've still got the option of informal negotiations with each of your creditors in the usual course. You can go to each of them and say, look, can we negotiate a reduced lump sum, or can we negotiate to pay this debt off over time? That's still available, but these plans, these debt restructuring plans, are similar in my view to what happens, as I understand it, in the US under Chapter 11 of the US Bankruptcy Code. And they're also similar to agreements under Part 9 and Part X of the Australian Bankruptcy Act for individuals. In short, as I understand it, you basically, as a company director, you say, look, we can't afford to pay all these debts that are less than $1 million within our creditors' payment terms. So what we're going to do, and we could never hope to do that. So what we're going to do is we're going to say, this is the amount of money we've got available to pay our debts. That means that each of our creditors are going to get so many cents in the dollar, and we're going to pay that by way of these installments. So a single installment then gets distributed by the registered liquidator, known under the legislation as a small business restructuring practitioner, but I'll come to that. and then the registered liquidator distributes each instalment amongst the creditors proportionately, depending on the size of their debt. And you therefore, at the end of the period over which those instalments are paid, receive so many cents in the dollar, and creditors would vote on that or approve that because they might take the view that that percentage of their debt is more than they would have received had they taken action against the company themselves or in any liquidation, any normal liquidation or administration. And at the same time, they don't have to spend any money on pursuing that debt. The debtor themselves comes up with a proposal at their cost, and the creditor just receives, without any outlay, a reduced sum, but over time. Look, following the initial announcement at the end or towards the end of September, there was some concern that unqualified pre-insolvency advisors could be a small business restructuring practitioner under these reforms, and there was concern because it's a reasonably widely held view in the industry that pre-insolvency advisors were unqualified. They're otherwise known as restructuring or turnaround advisors without any formal qualifications. There's some concern in the industry that they encourage or at least suggest or propose illegal phoenixing, where one company dies, but then a new company with the same directors and shareholders and assets pops up and just starts business again. That's illegal. It's not illegal, though, if the new venture purchases all of the assets of the former venture at market value. But following Treasurer Frydenberg's second announcement on the 7th of October, we now know that only registered liquidators can be a small business restructuring practitioner under this legislation. One practical tip that I would give is to communicate with your creditors, whether they be lenders or suppliers. Their support may be critical if your company is, or your client's company is, looking to undertake a consensual restructure, i.e. that informal negotiation I was talking about before, a debt restructure under this new debt restructuring plan scheme, if they're eligible, or a restructure under a deed of company arrangement if they're not eligible. And I should say that all of this that I'm talking about on this slide is subject to change, unfortunately, because the final details of the law have not been released by the government as yet, including, for example, the function and duties of the small business restructuring practitioner. Look, we're getting towards the end of time, so I might just jump forward to the next slide, a couple of slides, because there's a couple of things I just wanted to make you quickly aware of in addition to this insolvency law reform. There's this other piece of legislation that I found quite interesting, in the sense that in a nutshell, that's what it is there on the slide. But it's also due to commence on the 1st of January 2021, and basically this new act will establish a payment times reporting scheme, which requires businesses and government enterprises with an annual total income of over $100 million to biannually report on their payment terms and practices with their small business suppliers. Basically, we've got to tell the public how long they take to pay their suppliers and the first report's due on the 1st of July 2021. So that could be quite interesting, because one thing that I have heard anecdotally is that some of the larger players in our economy, the big miners and others, are now pushing out payment terms to 60, 90, 120 days, and that really hurts their suppliers, particularly if they're small businesses, cash flow. Might go on to the next one, please. And finally, So avoidable transactions, just quickly, are transactions in either bankruptcy or some form of corporate insolvency that can be set aside or reversed. Usually they're in the situation where a company or a bankrupt, an insolvent company or a bankrupt pre-becoming bankrupt or into some form of administration or liquidation or receivership transfers assets away in an attempt to prevent them coming into the hands of the liquidator, administrator, or bankruptcy trustee. In certain circumstances, that those assets can be clawed back for the benefit of and sold, and the money is distributed to the insolvent debtor or company's creditors. I'm going to focus just quickly on preferential payments. Now, that's a little bit different type of avoidable transaction where a company or a bankrupt pays money to its suppliers pre-insolvency in a certain period, usually 6 months, and then they go into liquidation, for example, and the liquidator can claw that back as a payment from the creditor who got paid for the benefit of other creditors, where that payment put the creditor who was paid in a better position than the other creditors once the debtor company became liquidated. I think usually, though, there is a defence to a claim for a preferential payment. So a liquidator comes along to a creditor who's been paid by the liquidated company in the 6 months before liquidation and says, "Hey, I'll have that money back, please." Understandably, the creditor comes to their lawyer and says, "Hey, listen, I did the work, or I supplied the goods. I've been paid for it. I can't believe that this liquidator wants me to give money back that I'm entitled to and due." Anyway, that's the law. But there is a defence where if the creditor did not know or had no knowledge or notice of the debtor's financial difficulty in the 6 months before liquidation, for example, then that's a defence to preferential payment, the usual defence. There's been commentary in recent times that defence will fall on deaf ears in the courts in a post-COVID-19 world, because everyone will or should or ought to assume that most businesses have been negatively affected financially during COVID. Now, some have done a lot better, but if you've got a debtor who is in one of the most affected industries by government restrictions like tourism, events, short-term accommodation, hospitality, and they were paying you slow, then you're going to be hard pressed to rely on that defence to a preferential payment claim that I spoke about. The solution, I think, is twofold. It depends on, you're better off getting early, but I'll come to that. The solution, I think, is if your debtor who's paid you goes into administration liquidation, and the liquidator administrator comes to you and asks for that money, or tries to call that money back as a preferential payment, then it's likely too late for anything other than, as I said, this defence probably won't apply, so it's likely too late for anything other than informal negotiation at that point. But that's not to be scoffed at, as administrators and liquidators can be quite commercial in my experience. So you can usually achieve a reasonable discount, meaning that you may not have to return all of the money that the debtor paid you in the 6 months before they became insolvent. My suggestion, though, would be to be proactive and seek to set up a preferential payment defence in advance. What I mean is, if one of your customers appears to be struggling financially, i.e. Paying outside terms or paying you off in instalments, then either get that payment from an alternative entity, so either a different company or perhaps even from a director personally, or seek to prove that the debtor company who's paying you is solvent by way of either statutory declaration from one of the directors or an affidavit, or a letter from their accountant, even better. But I would stop short as delving into their asset and liabilities position or profit and loss statements or things like that. I mean, they probably won't disclose that stuff to you anyway, but you don't want to know too much because what you may uncover may not be favourable, in the sense that it may put you on notice that they are insolvent and they're still paying you. Then you've absolutely got no defence to a preferential payment claim if they go into liquidation or administration later. That's the end of the substantive stuff that I had. Any questions, any more questions before I wrap up? No? Okay. Well, Karen, I'll go to the final slide. Thank you. Look, should you wish to discuss a particular matter or issue that you or your clients are facing, you can find my contact details on our website, which you can sort of see there in red on that last slide. It's cglaw.com.au. Otherwise, if you'd like to connect with me, feel free to add me on LinkedIn. I put all the legal alerts that are sent to our email database that I author or co-author on my profile there. Or otherwise, if you want to be added to our mailing list, please email Carolyn at CAROLYN at cglaw.com.au, or me, HARRISON at cglaw.com.au, or the general firm email address, mail at cglaw.com.au. And we'll happily add you to our mailing list. We've been reasonably prolific this year with legal alerts, given how much new law has been released because of the pandemic. Okay, well, if there's nothing further, no further questions, I'll sign off and hope you enjoy the rest of your day. I'll just wait a few more minutes here in case there are some burning questions, but otherwise I'll see you all at our next webinar or seminar, hopefully in the near future.